Hello, everyone. My name is Giovanni Nogales. I'm a paralegal here at Pecore. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Audit and Enforcement Risks Facing Hospice Agencies in Texas. Today's presenters are Richard Pecore and Matt Catoe. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them at the chat box and we'll address as many as possible at the end of the presentation. So without further ado, I present your speakers, Matt Catoe and Richard Pecore.
Good afternoon, folks. Thank you for being here today. It's always a pleasure talking to the folks at TAHCH. And if you would, Gio, let's go to the first slide. We've got some material to cover here for you today. Just to give you a little bit of the background, our bios are there if you want to read it. Just a little background on me. I'm a 30-year attorney, been at this in the healthcare racket longer than the 12 years I've been with Lyles-Parker. But both Matt and I work on regulatory matters, administrative appeals. I do additional billing contracts, third-party billing contracts, and a little bit of oil and gas. I went to the University of Texas and South Texas, if that matters. Matt, you want to chime in?
Sure. Hello, everyone. My name is Matt Catoe. I'm a new addition to the Lyles-Parker team. I graduated from Georgia State University College of Law. Like Richard said, I practice in the regulatory space. My experience is with anti-kickback statute regulation, Stark law, all the fun alphabet soup nobody ever wants to see in the mail. And I've done some time with the folks who are actually sending that angry mail. I worked with HHS in both their investigative arm and their legal teams. So I've seen both sides of the aisle, and I decided to come back to the light side of the force and help Richard here today.
It's interesting. You said did time. When you talk about the criminal side, you just get used to that sort of point of view.
Well, you know, lawyers choose their words very carefully, so do with that what you will.
Well, if you can't have fun, what the heck?
There you go.
Let's go to the next slide here. This is just the standard disclaimer. You know, if you think you have a legal situation, you need to hire a lawyer. You don't want to rely on general information that's not designed to address your specific circumstances and facts. So there you go. Next slide, please. So let's start off with this thing. Overview, government agencies or subpoena. What I do if somebody walks in the front door. Your first line of defense, we're going to talk about your contracts. Now, this could be your contracts with any contractor, but we're going to talk specifically about your billing contract because that is the one that frequently comes into play and generates a lot of problems, or if you have a good one, addresses a lot of potential problems. Then we're going to talk about prepayment reviews, additional document requests, post-payment audits, payment suspensions, basically anything that's going to interrupt your cash flow. Then we're going to talk about the bad stuff that Matt knows a little more about, subpoenas, search warrants, investigations, that kind of fallout. And he's also going to cover a very important area, excluded individuals. You don't want to get caught in that situation. Then his favorite, Stark and anti-kickback statute. Touch on self-disclosure protocols. There's a couple of them. We'll talk a little bit about HIPAA and patient abuse or neglect, basically right in the hospice wheelhouse. So then we'll wrap up with how you resolve the problems. Next slide, please. So here we go. So what do I do if a government agent is at the door or walks in or presents me with a subpoena? Well, don't panic. You want to get a breath, and the first thing you want to do is call your attorney. I'm sorry, that's the second thing. The first thing you want to do is ask them for ID. If they are from a government agency, or even if they're not, if they're a contractor, they're going to have to identify themselves. Now, you don't want to get in a fight with them. It's the same sort of situation as if you were on the street. You never win a fight on the street, whether it's with law enforcement or whether it's with documentation paperwork. You win it in the courtroom. So that's where the fight needs to happen. So you don't want to interfere with them. You don't want to get in their way. You don't want to argue with them. You don't want Do something that, especially if they're coming in with law enforcement, might get you shot or arrested. So use a little common sense here. The thing you're trying to find out is they'll give you a copy of any search warrant or subpoena that they've got. From reading it, you may be able to tell if it's civil or criminal. You'll be able to contact your attorney. You'll fax him a copy or snap a picture of it, send it to him, and he'll be able to tell you. And then whatever you're doing at the moment, just stop. Just take a breath, stop the bleeding. I mean, if it's billing that's the problem, stop doing the billing. If it's, whatever it is that they're starting to look at. Now, you don't want to volunteer information that's over your head. They may want to talk to employees, this and that. But after you've talked with your attorney, folks tend to get nervous and they tend to chatter and they tend to talk about rumors they've heard or this or that. The answer to this is that if you have direct knowledge and you're talking about something that they ask you specifically about that is in your job description, that you have personal knowledge of because you lay hands on it, then you can answer it. You answer truthfully. But if it's something that's not in your wheelhouse, to say, well, I'm not the right person to talk about that. This person over here handles that. I really don't know anything about it. You want to gather all necessary documents or whatever documents that they are looking to get. If they tell you they just want you to point at them and they're going to get it themselves, get out of their way. Don't try to interfere with them. If they're asking you for assistance in getting the records, then get the records they ask for. Make sure you get all the records they ask for, but you don't give them beyond the scope of the subpoena or the search warrant. And your lawyer can help you at this point, and they'll be on the phone with you. Get an exact or make an exact copy, if it's electronic, of everything that they take or that you pull for your attorney. Because the worst thing you can do, and we've seen this many times, I know you have too, Matt, I've run across this where I get called, 2 weeks later and find out that they came in and took a bunch of documents. What did they take? Well, we don't know. What do you mean you don't know? Well, they just came and took a bunch of stuff. Well,
Yep.
You need to have a copy of what they pulled. You don't want to be in that situation of having to depend on the government to get a copy back of whatever it was that they seized or you took over to them, if it's at all possible. But above all, you do not ignore the problem. This is not something that's going to go away. Next slide, please. Matt, do you have anything to add to that?
Actually, I just want to double down on the keep notes and records. The magic phrase is some variation of, you want to work with the agents when they show up, and you want to be nice and cordial and professional, as we all are, but you play every variation of the I don't have a lawyer and I feel like I need one card. Respectfully, I don't want to answer any questions at this time. Because if they're very serious about getting the answers they want out of you, they'll be back, and at that point in time, you should have a lawyer. And to echo what Richard said, if they take anything, pictures, documents, someone's statement, someone chatters, there needs to be a record for when the attorneys get involved so we know where we're at and how bad the damage is. Because the worst thing you want to do is pay for an attorney's fee for 3 weeks playing catch up, trying to figure out what's no longer in your system and what the government might or might not have.
And I should add here, there's nothing wrong with saying, hey, I need a copy of that. If you didn't hand it to them and they're just seeing something they like and they grab it and say, I'd like to get a copy of that. And if they won't do that, if they won't release it to do it, then say, then can you tell me the name of the document or what it is or where you found it? I mean, that situation can come up, but generally you're going to be able to get a copy of what's being pulled or seized because they're usually going to be asking for your help.
Mm-hmm.
So your first line of defense is going to be to strengthen your compliance program. At this point, everybody should have a compliance program. They should know what it is. they should also understand that this is your first line of defense. This is the best way to address fraud before it happens, billing problems or issues that could cause adverse actions by law enforcement or by regulatory agencies or contractors. You want to get ahead of the problem, and this is how you do it. So every compliance program should have these 7 elements. It's in the federal regulations: written standards of conduct, policies and procedures, designation of your compliance officer and or compliance committee, conducting effective education and training. And boy, as a former HIPAA trainer, I want to tell you that this is something that folks neglect. It's not just a tool for introducing them how to do their job. It's a tool for adjusting to problems that you identify, to risks that you identify, to creating new policies and procedures and getting everybody on the same page, and then following up and keeping them on the same page with those changes. Because we're creatures of habit. Everybody falls into bad habits. So this is how you stay on top. You want to develop effective lines of communication, including process such as hotline to receive field complaints. You enforce these standards through well-publicized disciplinary guidelines. It's a lot of flowery ways to say, put on paper so folks can read it. Conducting internal monitoring and auditing. Again, this is something that's neglected. If you're not doing internal auditing, there's no way you're going to stay on top of or head off these problems with regulatory violations. So it's a must. Responding promptly to detective offenses and developing corrective actions. Again, this kind of goes hand in hand with the education and training. The corrective action plan is your map on how you're going to address this and how it gets implemented. And then following the results afterwards so you know the problem's been addressed and the problem's been fixed, or if it's still continuing. So you're going to know. Next slide, please.
Before we get started with the next slide, I do want to chime in on those last 2 points. I personally have seen several audits that the government got involved or took interest in an audit target years before anybody showed up at the door or the paperwork started moving. And they sat on it and said, this individual, this clinic, I remember one particular time when I was working with the investigation team, we had our eye on the doctor in Louisiana. And his clinic had popped on the magic spreadsheets that the government keeps in, I believe, 2015. And they didn't move on him until 2020. And just to go back to what Richard was saying, you can cut that off at the source if you set up a rigid and effective internal compliance program just to double check yourself from time to time. It can be quarterly, it can be biannual, but as long as you're doing the internal monitoring and auditing, you can get ahead of the curve before you even know there's a curve to get ahead of. Sorry, just wanted to add that.
No, I appreciate that, man. That's so important because it's a course corrector. If you're off course, you can adjust the rudder and you can get back on course. This is a tool. It should be used as a tool. You don't just keep wandering ahead and hope everything's okay. This is probably, aside from the military and nuclear power, the most heavily regulated industry, well, on the planet for that matter, but especially in this country. And you should treat it that way because, believe me, there's plenty of laws and regulations out there that are going to treat you that way. Next slide, please. So let's talk about changes that are coming, because you may or may not have seen this. I hope you have, because it came out last November. The OIG model compliance guidance for hospice agencies is due for an update. Now, they came out in April last year and said there's going to be major updates to all the compliance guidance, which is, most of them are from the late 90s, 98, 99, around that era. So they hadn't been changed in a while, but they came out recently, last November, with a major update for the compliance program guidance generally. This is something that applies to everybody. And you see what the cover looks like over there. The link is right above. There's the federal reg citation for it. Now, that's the old one, and you can see what's changed since then, but the link there will go to the new one. Now, besides this, OIG announced the industry-specific compliance guidance that's coming out, the CPGs and the ICPGs. And that's where these next rounds are coming out. We don't know when hospice is coming out. It could be 2025, it could be later, 2026. They have listed nursing facilities going to be the first one out. It's already due or overdue. It's supposed to be in late 2024, so it could be, last quarter or first quarter 25. It's going to be followed by Medicare Advantage, hospitals, clinical labs in 25, and then hospice and pharmaceutical manufacturers. So as we talk about these risk areas, understand that changes are coming. It's going to be more demanding. And this is where your compliance plan comes in place, because first we're going to talk about known risk areas for the hospice industry. That applies to everybody across the board. But then you want to look at things like the compendium on the annual OIG work plan that comes out every year. And that's going to talk about new areas they're looking at, and also your own specific business where you should be doing an annual risk assessment. And if you identify other specific problems to your hospice or area, you need to be addressing it. You need to have a policy or a procedure on that. Next slide, please. Matt, do you have anything to add on that? We'll just launch ahead. First, we're going to talk about these 28 known risk areas. And the reason there's a number after it is because the Federal Register link that you go back to on the 98 guidance or 99 guidance has these footnote numbers, and they have whole paragraphs on it. So if you want to find out more, go to the Federal Register and read what all the footnotes say about each of these to get a better understanding. It's not a bad idea to download that and read through that. So this is what they know are problems for hospice, so pay attention here. Uninformed consent to elect the Medicare hospice benefit. You've got admitting patients to hospice care who are not terminally ill, double billing arrangements with other healthcare providers who a hospice knows is submitting claims for services already covered, underutilization of services, falsified medical records or falsified plans of care, untimely or forged physician certifications on plans of care. That means if it's late too. There's no reason to miss these deadlines. Doctors are notorious about paperwork, but you need to write them. Inadequate or incomplete services rendered by the interdisciplinary group. Insufficient oversight of patients, in particular, patients receiving more than 6 consecutive months of hospice care. They know these are problems. Hospice incentives to actual or potential referral sources like physicians, nursing homes, hospitals, patients, etc. They could violate the anti-kickback statute or other federal or state statutes or regulations like false claims, and that includes improper arrangements with nursing homes. Overlap of services that a nursing home provides, which results in insufficient care provided by a hospice to a nursing home resident. Next slide, please. Improper relinquishment of core services and professional management responsibilities to the nursing homes, volunteers, and privately paid professionals. Providing hospice services in a nursing home before a written agreement has been finalized if required. And don't forget, you're going to get a copy of these slides, so you'll be able to read through these again, but they are in the Federal Register. Billing for a higher level of care than was necessary. Upcoding. Knowing billing or inadequate or substandard, knowingly billing for inadequate or substandard care. Pressure on a patient to revoke the Medicare hospice benefit when the patient's still eligible for it and desires it, but the care's become too expensive for the hospice to deliver. So you're looking to get rid of the patient. Billing for hospice care provided by unqualified or unlicensed clinical personnel. That's just inexcusable. False dating of amendments to medical records, high pressure marketing of hospice care to ineligible beneficiaries. And anytime you're involved with marketing, there's a risk, because inevitably you're going to run afoul of the referral prohibitions where you're getting kickbacks or they're paying patients. You got to be really, really careful with the marketing. Improper patient solicitation activities such as patient charting, improper management and oversight of subcontracted services that results in improper billing. Next slide, please. Sales commissions based on the length of stay in the hospice, deficient coordination of volunteers, improper indication of the location where hospice services were delivered, failure to comply with requirements for verbal orders for hospice services, non-responses to late hospice referrals by physicians, knowing misuse of provider cert numbers, which results in improper billing, of course, failure to adhere to hospice licensing requirements and Medicare conditions of participation, and knowingly failing to return overpayments made by federal health care programs. A hospice's prior history of noncompliance with statutes, regs, and federal health care program requirements, the rules of the program, Medicare, Medicaid, TRICARE, FELA, may indicate additional types of risk areas where the hospice may be vulnerable, and that may require policies and procedures to prevent recurrence. As I said before, these areas, and plus any of the areas that you identify in your annual security rule risk assessment, which you should be doing, they should be addressed in your compliance plan. And either you're going to have a policy, or if it's an ongoing problem, you deal with it with policy and procedure, how your folks deal with it. Matt, have you got anything to throw in on this one?
No, I think you've hit all the major highlights on these ones.
The main thing is to understand that this is guidance. It's not a complete list. And your business is unique. It's going to be different. So the particular problems that you run into, you need to identify. You need to create a policy and procedure for it. That policy and procedure needs to be in your compliance plan, because the first thing investigators are going to ask is what, Matt?
They're going to ask, what is your compliance plan and where is a copy of it? Because we want to see it.
Yep. They're going to want to know if you've known about this problem and whether you did anything about it. So it's not just lip service we're paying to this. It's a tool. Use it. Next slide, please. So what's a payable claim? If you want to know, you can download this list at the link there. We've got a list on lylesparker.com. Robert W. Lyles created this list. He was also involved with the Clinton administration setting up the first federal task force on fraud, waste, and abuse enforcement. So he pretty much wrote the book on this stuff. So when he tells you that element 1 and element 5, which are in red, are the most important, this is where you run into the most problems. Medically necessary. You got to document it, and you got to document it thoroughly. And that does not mean using cloned notes. That is the corollary to medical necessity. That's a big stinker. And it's one of the top reasons why claims get kicked back and why you run into problems. Now, it doesn't mean that if you have a patient that's either stable or is slowly declining that you can't include information from previous reviews, but it can't be just that. There has to be new information, and that means more than just their pulse and heart rate. So, it's got to be different. It's got to be added to. You got to have observations and responses. So keep that in mind. The medical services on number 5, medical services and supplies provided were fully and properly documented. This is all about a paper trail, folks. You got to make sure that it's coded and billed, but there's got to be the documentation that fully supports the claim, that's how you keep them from getting kicked back. That's how you get them paid. And that's how you keep the machinery running. Anything to add, Matt?
Yeah, actually, the properly and fully documented and the medical necessity, we've seen a variation of pushback on those where a doctor's office or a hospice group may say this is very clearly medical necessary, and whoever's counting the beans over at the insurance company says, well, we think a patient who's missing a leg could have benefited from physical therapy. The other side of this coin is if you don't get it paid up front with what is asserted as very clearly medical necessity, it helps on the back end if you ever go to appeal it, where your lawyers can point to, did you not read the 4 paragraphs that they wrote where this patient was suffering from all these debilitating chronic conditions? And it makes it an argument stronger if and when attorneys have to get involved. So it's a double-edged approach. You get it paid on the front end, or if for some reason someone pulls something out of the clear blue sky, you can reassert, I wrote it was medically necessary for these reasons. Here's all the documents and all the medical services and all the supplies that I used to the absolute best of my ability to record. And it helps on multiple fronts.
That is a great point, Matt. You're helping your lawyer out, because for claims that get kicked back, and it's going to happen eventually, and if you get audited, you could have a pre or post payment review. You could wind up with multiple claims on a spreadsheet that's got to be addressed. The most I've ever had to address at one time was 12,000 claims. That took a while. But the point is, the more you have in the record to help support that, the more tools you give your lawyer to help you win that claim. So the better you document all your claims, the better it works. It's really not possible to over-document a claim. Next slide, please. So let's talk about contracts. Contracts in general with third parties should be something that is more than just 2 pages you copied from the internet because you were in a hurry. It needs to be something more that's going to help you or protect you. So we're going to use a third-party billing contract. You may have a billing department, but chances are at some point you've either used one or are going to. So we're going to use that as an example. Examples of provisions, you're going to be wanting to identify each party, what their duties are, what their rights are, what their obligations and remedies are. So you want to include a termination provision that's going to let either party terminate the contract at will, which means like right now, if there is an unhappy parting of the ways, or for cause. If there's a reason, and the best example I can give you is if you get the fishy client who's either stonewalling you every time you ask for documentation, or just ignoring you, or actually gets hostile to you. Just process it. Just do it the way we've always done. That is a huge red flag, and you need to cut bait and get out. The biggest thing I run into when I'm dealing with third-party billers, especially if they're small, is they're afraid to fire clients. So understand that if this is how you treat your contractor, you might be looking for a new contractor because they might can you, and that can happen. So as a good provider is going to want to provide that documentation, because again, it's all about getting the claims paid. So when you're a hospice provider, you've been subject to an adverse action such as a prepayment review, payment hold, suspension, or law enforcement otherwise impairs your ability to pay, then you understand that the contract is not just something that the biller's going to want to terminate because they don't want to have to supply free services. You're going to be looking to, your cash flow just got interrupted. So you're looking to cut costs. So being able to terminate the contract is also going to help you out. And that's something that you're going to have to deal with. Now, you're still going to want to submit claims and stuff, but you may want to look at it from the in-house point of view at that point, because it's all going to go into an escrow account until you can get the problem resolved. You want to identify in the contract who handles requests for refunds from either payers or patients, responsibility for who's going to do the credentialing, what information is going to be provided by the hospice provider to either the biller or, for that matter, patient interface. That's not in the biller aspect, but that's something with your contracts that you want to deal with. Part of responsibilities, who's going to do the coding, what level are you going to do? If you have your biller doing minor corrections and approvals, you need to spell out specifically what they can and can't do, and that they need approval, which means they're either going to make the change and submit you a list for approval, or you're going to have to sign off on every single one before they can do it. So minor misspellings, technical errors, obvious typos, things of that nature. That's something you want to address and anticipate. HIPAA compliance establishment and coordination of compliance efforts. When your biller runs into a problem and they tell you it's a problem, work with them. Try to resolve it. There's where your corrective action plan and your policies and procedures and your training can help you stay on course. And if your biller's telling you, look, we keep getting a bad code on this, and they're going to kick it back, address it. Insurance responsibilities, you want to look at E&O and cybersecurity. You may even have legal insurance available to you. It all depends on how much money you have, what you want to spend on it. Next slide, please. Examples of other provisions, right of the billing company to conduct periodic audits. Now, why would they do that, and why would you have a problem with it if you're a provider? Well, if the biller is seeing something that doesn't make sense to them, and it's not time for your semi-annual audit, which you should be doing, maybe you do it quarterly, but at the very least, you should be doing it annually. If they see a problem, they can pull a sample. They can look at it, try to figure it out, and you can correct it mid-course before, you go another 6 months and get to it. And maybe you discover it, and maybe you don't. She's seeing it or he's seeing it in real time right now. So they can look and focus in on that, and you can come up with a corrective action plan. Responsibility for maintaining secure direct facsimile numbers and HIPAA compliant secure email. That's not just email, it's all communications. If you're doing testing and you're sending information back and forth, it better be a HIPAA secure program. Establishment of business associate agreement with the billing company, and understand you could have a version of it, they could have a version of it, it's fine. Basically, what they both say is that you're going to abide by the law, federal and state law, and that means all of it, as well as program rules. No responsibility to bill claims where insufficient or ambiguous support. This is what I talked about if you get the fishy client. This provision should be in there for the biller's point of view. And if you are a viable biller, that's part of your duty to provide full and complete billing to support the claim, and you shouldn't have a problem with it. Indemnification clauses, I've always been on this. You can use it, it can be used as a negotiating tool, but in the end, you're responsible as the provider for whatever your contractor does anyway. And the contractor's not going to have the money generally. You're going to have the money. So whether you guys want to argue about indemnification as a way to address potential liability is up to you. Oh, goodness. Was that me that did that? I've got the whole screen zoomed out here. There we go. Something happened. Okay. Okay. Well, I think I had one more. Can we back up one? Compliance addendum. Background checks are vital. I do background checks on all my clients, frankly. I've been lied to too many times, and I like to try to head off problems before they happen. So before you go into business with somebody, do a background check on them. Talk to some of their former clients if you know anybody who's done that. and make sure these guys are on the up and up. Next slide, please. Starting to edge into Matt's time, so I want to wrap up. Billing agreements, the federal limits, as far as the law goes, the only time you run into a problem on billing, as far as the method, is percentage-based, because it runs afoul of fee-splitting laws and kickbacks for referrals. That's what you have to be careful of. Literally every other state is okay with either flat rate, hourly, or volume-based or per-claim billing. They're okay with it. The only problem you run into is percentage-based, and every state is different. So you've got to know what that state is, especially if you're dealing with multiple locations or your biller is in another state, because the biller will have to comply with both states' laws, their own and yours. New York is the hardest. They prohibit any sort of percentage-based billing. Then there's some states like Texas, Florida, Alaska, where they're okay with percentage billing for Medicare, but not for Medicaid. And the only place in Texas that it says that is one sentence buried in the middle of a 70-plus page provider application. Now, that sentence used to be black and white and prohibit clearly, said no percentage-based billing. It was easy to understand. Then along around 2016, 2017, the state changed it. But for 40 years, the state of Texas has been hostile, extremely hostile, to percentage-based billing in Medicaid claims. And the current sentence is basically, it means whatever we say it means. There's no way I recommend to a client that they should take a chance on percentage billing on Medicaid in Texas. Not until they give me something as an attorney representing you that I can point to a judge and say, this statute or law or contract provision says my client can do percentage billing. That doesn't exist. So a bunch of the other states either limit the professions or they restrict or limit or put other conditions, like you can't have controlling interest of 51% controlling interest in the practice if you're a management service company, or you can't have control over the bank accounts, and you're going to exchange fair market value for the services. All of them, every contract, every law that addresses it says no kickbacks for referrals, no money for referrals, no percentage on referrals. You don't do referrals. This is why it's a problem. States don't penalize you. You don't have the money. They don't license you, and usually it's the licensing boards. They penalize your client. They could lose their license. They could have fines of $5,000 to $10,000 per instance, face suspension, revocation, or even prison. So next slide, please. I think this is my last one.
Mm-hmm.
So the question, was this care medically necessary? For prepayment reviews, ADRs, post-payment audits, and suspension. Actually, I think I'm edging into your stuff, Matt. This is where I think you were going to jump in because we changed categories.
You're right before mine, but I'll be happy to take over if
Why don't you grab this one, because this whole section is going to talk about each one of those topics as they go red at the top in sequence. So you're going to talk about the others. Why don't you talk about this? Let her rip.
Sure. So like Richard said, we're getting into prepayment reviews and the ADRs. And this is the first sign that a insurer or a billing company has an issue with your documentation. The first thing that we're going to do before we send any claim in is determine, like Richard was saying, was the care medically necessary? And as we went over previously, this is decided in your documentation. Anybody who's involved in the claim can swear up, down, and sideways that this was medically necessary, but what it comes down to is what your attorneys can point to on paper and say, this is very clearly medically necessary for this patient for any number of reasons. This is supported with the follow-up questions like, is there any evidence that the services were actually provided? if you have a serial number for a graft that you applied for a patient, or if you have a specific batch of medication that came in and you can put that in the chart with relative ease, do so. Are there any statutory violations? Have all the coverage requirements been met? Was the claim properly coded and properly billed? Now, keep in mind, those are two separate things. Coding is one end, billing is another, and you need to be aware that everything's on the up and up to the best of your ability before it goes in to avoid a prepayment or an ADR. And finally, can you anticipate and field the most frequently cited denial reasons? This is usually just coming down to familiarity with the field. As you get more involved with your clients or your providers or your billers or anybody involved, you're going to know, hey, this patient or this medication or this particular procedure happens to get kicked back with a higher percentage frequency more than others. What can I do? What can I put in this documentation to say individual insurance carrier or whomever is paying this claim, Medicare, Medicaid, TRICARE, insert alphabet soup here. I know you're going to try to say A, here's B in response before you even get there. And like we said before, head it off at the pass. You want to review your contract with the healthcare provider, choose a state compliant billing method. As Richard was going over in the previous slide, percentage-based is kind of up in the air. It's a jurisdictional-based matter. The state of Texas is becoming very hostile to it. So if you're even considering a percentage-based agreement, look very, very carefully at all the fine print. Save yourself the time and headache of getting lawyers involved and make sure you're on the up and up before the word go. Hourly-based agreements, if your provider client is placed on a prepayment review, you should still be paid, as with per claim agreements. Finally, flat fee-based agreements. In my experience, this is looked on the most favorably because the numbers don't change in a flat fee. As with per claim and hourly agreements, a flat fee protects the billers to the highest degree possible. Moreover, a flat fee is highly recommended from the HHS OIG compliance standpoint. Those are the folks that I used to work with. They really like it when the number is flat and non-moving in relation to the number of claims, care provided, what have you. It really helps carry a lot of weight from the front end. Next slide, please.
Matt, I'd like to add one thing.
Sure.
If I could, is that the reason this is a problem is because everybody used to do percentage-based billing, and a lot of doctors are not aware that that has changed. The reason it's changed is because these laws were always on the books. There were always restrictions on the percentage-based billing in virtually every state, but nobody enforced it. Guess what? Now they're enforcing it. Once New York did it back in 2016, I think it was, folks started figuring out, hey, we can put 3 people on this department and get a bunch of money back for a Medicaid program. That's why everything's changed.
Yep. And the general thing that all providers need to be aware of is the rules will change. So if you can set up any kind of web check on Google or what have you, you got someone in an IT team or a particularly tech savvy intern, it's better to keep an eye on the rules. As annoying as it is to have one more thing to do, if they change and you know about it, you can be proactive rather than reactive. Next slide, please. So these are post-payment audit reviews. Now, this is where we really start getting into the weeds. To highlight a point Richard brought up earlier, if an audit comes in the door, get an attorney involved, because at the point in time that we're doing a post-payment audit review, there's likely some element of a clawback or an overpayment or someone somewhere saying, you owe us money that we already paid you. And this is where things can get really dicey, because most times that money's already been spent on general upkeep, if nothing else, let alone all the medicine and all the supplies that are going in and out of every individual clinic. Most of the time, that money's already been put to use, and this is where you need to be really on top of your documentation, really in communication with your attorneys. Like we have in the first bullet point, your assistance will likely be needed to pull, analyze, and submit additional documentation. Do you have anything in your contracts to provide compensation for overtime or additional unforeseen hours? and it can easily, very, very easily, get into 20 or 80 hours. This goes back to when the government agents show up and start asking for everything. We've seen periods of time range for several years. I remember one time when I was with OIG, we asked for 25 years of documents. So just think about how many patients come in and go out, how long their medical records are in the 25 years an entity can exist. This can get lengthy, and the cleaner and easier you can move through your EMR, the less painful it is for everybody. And that goes to the second bullet point. Review the claims and supporting documentation before you send it in. Head this off at the pass wherever you can. But if we can't, and we do have to go to a post payment, what if you are paid based on reimbursements or collection and payment is delayed? Are you able to terminate the contract? Or do you have a get out of jail free card? If so, what is it? How painful is it to pull in? Can you get insurance involved? These are all questions someone in the organization needs to have an answer to, and you need to know who that is, going back to the points we brought up earlier. Now, there is an extraordinary backlog in the appeals process. An average time, like we have on screen, is 6 years to the ALJ. It is very likely, in fact probable, if we're all betting men and women, that someone's going to try to start a recoupment process before the hearing date occurs. That means they're going to start garnishing, they're going to start taking off of new claims, they're going to start taking and taking and taking because they have asserted that they are owed money that was already paid, and they're going to take it back. My phrase that I learned when I was doing regulatory work is the government has a magic spreadsheet somewhere in DC or some data bank somewhere. If a post-payment audit occurs, your clinic or your client has popped red, and the government will balance the books against you, whether you like it or not. It can be painful or it can be straightforward, but they will get their money back. And that's where the recoupment process occurs. So you need to know, how will you be paid if those Medicare payments start getting recouped? Whose fault is it that a claim is improper? Why is the claim improper? Will the provider point the finger at you that your billing company is at fault? Will you point the finger at the provider? And why? Back it up. Have you provided incorrect advice to the provider? Going forward onto that, when the fingers start pointing and the documentation starts flying, it's really easy for tempers to get heated. It's really easy for people to start getting mad and saying, he said, she said, they did, they didn't. The name of the game is keep a level head. First, do you have E&O insurance? And if not, why not? Protect the runners of the business so that they can keep the lights on while the attorneys and everyone else sorts this out. There will be, like we said, a long time. These matters can get extensive and thorough and down in the weeds. The building needs to keep running. The business needs to keep bringing in cash flow. E&O insurance can help with that. And finally, there is an obligation to repay overpayments within 60 days if you knew or had reason to know. And I have seen time and again, people will throw that language around of you shoulda, coulda, woulda, known to pay this back within 60 days. If they can pin you on you knew or should have known within 60 days of an error occurring and you didn't file a repayment, well, congratulations. Here's another 7 pages of documentation and another, I don't know, $900 out the door per hour you have to have an attorney. It gets expensive fast, which is just going back to what Richard and I were highlighting earlier. Just do your due diligence on the front end. It's painful, it's annoying, but you will save yourself so much headache going forward. Next slide, please. Suspensions. So this is the big death knell. This is the one you don't want to see. This is the biggest gun that I am aware of outside of actual criminal allegations that you see. From the provider perspective, a suspension of provider payment usually comes after a quote-unquote credible allegation of fraud. It's usually a minimum of 6 months and can be renewed for another 6 months unless you can test it. They may continue to see and treat Medicare beneficiaries, and they may continue to bill for services rendered if the suspension allows for it. You have to be very clear on what you're suspended for and how deep does the suspension go. Reimbursements will be held in an escrow account at a UPIC or a ZPIC until they resolve. If your provider is on the suspension list for any reason and they happen to draw the quote-unquote lucky number that lets them continue to see Medicare beneficiaries, they're not going to pay right up front the way they would for a non-suspended individual. They're going to put it in escrow and double and triple check and go all the way down into the commas and the periods of what is on this documentation before anybody sees a cent of anything. And it can cause a cash flow crisis. If you're a one or two practice or two provider practice and one of them goes on the suspension list for reasons good or bad, can the group survive? This is also why I see something in the chat. Richard is saying this is also why you want to get your attorney involved early. When you discover an overpayment, you need to do an analysis to see how far back and how deep that error goes, how many claims are involved, and is this the correct amount? Again, the more documentation you can provide to your attorneys answering those questions, the easier it gets for us to fight for your behalf and to argue it once we get involved. From the biller perspective, the other side of the house, there's a contract issue. How does this affect your compensation as the billing company for the provider? Should you terminate? That's a business decision. And what is the risk if you don't? Are you a target? Will it spread to you? Will it spread to your other clients? This is the ripple in the pond problem. These investigations get wide quickly, not necessarily because the government is pointing fingers at everybody who ever did business together, but if party A is on a suspension list and they get tagged, they're going to ask, okay, who'd you do business with? What do they have? Are there emails? Are there phone calls? Are there medical records? Are there text messages? Where can we get them from? Party B may have no idea what's going on, but they've got documentation from doing business with the now suspended party, and the government wants it. Do you want to take on that risk? You have to ask that. The example that we've got on screen is February 2012. There was a Rockwall, Texas doctor who was indicted on a $375 million healthcare fraud scheme that resulted in the suspension of 78 Dallas-Fort Worth area home health agencies who had done business with the provider. The suspensions were all based on a credible allegation of fraud. So the first thing you have to ask yourself as a biller, from the biller perspective, are you implicated? If so, how deep does it go? And that's the point in time you want to start calling attorneys and getting people on the phone. Next slide, please. So I'm running a little tight on time, so I'm going to try to pick up the pace. We will provide a copy of these slides, as we mentioned previously, but if anybody has any questions or comments, please feel free to put them in the chat, and Richard and I will address them as we can. So the first things first is we need a copy of the relevant document. We need to see whether it's a subpoena, a search warrant, or an investigation or fallout procedure. Why are the investigation agencies here? Call your attorney ASAP and provide them with that copy. Show them this is what they gave me. This is what they said they're there for. We look that over and we say, okay, this is a subpoena. This is a search warrant. You're under investigation. Whatever the answer is, we need to know as fast as possible. If it's a subpoena, you might have some time to respond. Let your attorney work through those mechanics of how and when, but you might have some time to get some documents together. If it is a search warrant, to re-highlight what Richard said at the beginning of the presentation, do not stop the agents. Don't lay hands on them. Do not prevent them from accessing any room. Do not prevent them from leaving with anything that they believe they are entitled to take. If there's an issue with the search warrant or any of the documentation, HIPAA allegations, private health information, leave that for your attorneys. It gets infinitely worse if you attempt to stop a search warrant in progress. Just let them take it. You don't necessarily have to help, but you cannot obstruct. And as we mentioned previously, be sure to take notes of exactly what they take. If you have a business interruption contingency plan, get it running, get it going, start tagging people, and be prepared to release a public statement that was reviewed by your attorney. Train your staff to deal with questions from the client and the public because they will ask. And most importantly, from my personal experience, do not give an interview without your attorney present. This is the golden rule of I don't want to answer questions without my attorney present. The agents may try to bluster, they may try to threaten, they may try to be nice. If they start asking questions or say, hey, can you come sit in this room with me answer a couple of questions. Sir, ma'am, whoever, I don't want to cause a problem, but this feels like something I need an attorney for, and I'm not comfortable answering your questions without one. Sorry. If they're really into it and they want the answer to your question, you to answer their question, excuse me, they'll be back and you'll have an attorney. Do not give an interview. Just don't. Full stop. The example we have on screen is Merida Health Group, Texas, January 2018. There was a licensed physician who received $5,000 in kickbacks for referring hospice patients. When the investigation began, he called that individual and told them to lie to the FBI if they were interviewed. When that physician himself was interviewed by the FBI, he also lied and denied accepting the kickbacks. The indictment became unsealed in January 2018. Various individual trials were scheduled for 2019. I don't think this needs to be reiterated, but we do have it in red for a reason. Don't do that. Do not emulate this. Don't lie. Just don't answer the question. There is a difference between respectfully and politely not answering versus an outright lie. If you are convicted for making a false statement, you could go directly to federal prison. Do not pass jail, do not pass go, do not collect $200. You lied to an investigating agent. That's an entirely separate matter from what they're there for. You lied, conviction of a false statement. Or 8 years if it's related to an act of terrorism. Rare, but occurs. It's a federal felony that will cost you the rest of your life. And there's a citation if you want to double check me. Next slide, please.
Matt, I'd like to add something here. We're going to run a little long, and frankly, that's my fault. I apologize to you, Matt. But for the folks that need to leave, you'll get a copy of the slides, as Matt mentioned. But there's a lot of important information here. So I think Matt's doing a terrific job. And rather than cut him off, Matt, I'd like you to keep going and finish the presentation. Anyone who can stick around for it, you're certainly welcome. We'll go as long as you're able, but we'd like to finish this for you. And if you can't stay, we certainly understand. And I'll let Matt continue.
Sounds good. So I misspoke a little bit earlier. I said the suspensions were the worst thing. The exclusion is the worst thing. Suspensions are more common, which is why I preface them with this is the big one. Exclusion is the biggest one. This is the absolute, you are not allowed, full stop, to bill. There are three primary reasons, or three primary lists to be checked monthly. And the reason why is because exclusion regulations are tied to every state Medicaid program, not just yours. OIG recommends that exclusion checks are performed prior to employment, along with a criminal background check, and on at least a monthly basis thereafter. Bringing up a point Richard brought up earlier, some attorneys are just, we've been lied to. We've been lied to too many times. I'm not on the exclusion list. I'm not on the exclusion list. Well, I pulled your record and you're sitting on this exclusion list and have been for a while. The lists are on the screen. There's a couple links. There's the first one. That's the OIG's list of excluded individuals and entities. That's usually, though not always, a result of an HHS investigation that resulted in a guilty verdict of some kind or caliber. Those are your big ones of these people are not allowed to bill Medicare, Medicaid. The GSA System for Award Management Exclusions List, or the SAM, is a similar counterpart. It's another exclusion list. You need to check it for all of your people that you can. There is a state-specific Medicaid exclusion list, and there are state-specific Medicaid exclusion lists for other states. Consider a subscription service because these exclusions do not expire. And it's helpful if you have screenshots. Save it, hey, this is the list as we pulled it on, I don't know, January 5th of this year. As of January 5th of this year, if this individual shows up for employment or opportunity or tries to offer us a billing arrangement, they're on the exclusion list. Do not do business with them. You can apply for removal from the lists and reinstatements, but you must have a written letter from the OIG saying, we have seen and heard all the evidence and we agree this person should come off the exclusion list. Otherwise, do not use them. Special Advisory Bulletin from May 8th in 2013 says, excluded persons are prohibited, full stop, from furnishing administrative and management services payable by federal healthcare programs. This applies even if those administrative and management services are not separately billable. An excluded individual may not provide other types of administrative and managing services such as health information technology services and support, strategic planning, billing and accounting, staff training, and human resources unless wholly unrelated to federal health care programs. That is about as broad and about as sweeping as they could have possibly written that. You cannot work with an excluded individual, and it falls to you to figure out who is and isn't an excluded individual. And there's the link if you'd like to double check me. Next slide, please. So there are a few things that go into the exclusion. It could be a provider action. Check the LEIE, the SAM, and the state exclusion list for each employee hired or contracted with when that hiring occurs, as well as all current employees and contractors every 30 days or so. We like to believe everybody's on the up and up, but just in case something tries to get slid under the rug, you need to know about it. Retain proof through your screenshots. Include provisions in your billing contracts placing a similar responsibility on the billing companies to perform searches for their employees and contractors, and conduct this due diligence is being done via confirmation of reports or assurances. Just make sure everyone's on the up and up. It's just a double check so that no one comes knocking at the door saying you're doing business with someone you shouldn't be. If it's a biller action, you should do the same with your own company employees and contractors, and expect reasonable providers to include this as a contract provision with requests for confirmation or assurances. Just back up your story. I'm not on the exclusion list. Here's a screenshot. My name's not on there. Can we continue to do business? What happens if you did use an excluded individual? If the provider or biller finds out that you used an excluded employee or contractor, consult or hire legal counsel immediately to plan next steps. Counsel will likely advise using the voluntary self-disclosure protocol to calculate likely overpayment amounts and damages and help you determining which entity, because there's a lot of them, should make the disclosure, how it should be made, and contacting the OIG. I want to take a brief sidebar. It's not on the slides. The self-disclosure protocol, it gets a lot of a bad rap because providers consider it inviting the OIG to look in. I can say from personal experience, if through counsel you're recommended to make a disclosure, the penalties fall off a cliff as opposed to if they had to come looking and verify for themselves. Consult with a lawyer, and if they advise you after reviewing the facts of your case that a self-disclosure is necessary, you can feel free to question them on it, but it's usually better to go along with it. I just want to point that in there as a bullet point. An overpayment and a CMP, the excluded employee could taint every single claim filed since their hire and create an overpayment issue that you must now defend. Also, per OIG's Special Advisory Bulletin, a provider is subject to a civil monetary penalty law exclusion if an excluded person participates in any way in the furnishing of items or services payable by a federal health care program. This includes administration and management services, as well as contracted billing services where the person or entity furnishing these services knew or should have known. And that or should have known is in the hands of the person investigating you. Just don't play with fire. Don't hire the excluded people. Check if they're excluded, and if they are, you got to let them go. Kick them to the curb, get them out of here as soon as possible. The OIG's Special Advisory Bulletin also states the provider can reduce or eliminate its civil monetary penalty liability if the provider is able to demonstrate by exercising due diligence and following up that it reasonably relied on the contracted entity to perform a check of the LEIE for those excluded individuals. You can point the finger elsewhere, going back to the compliance program. Whose job is it to check? When do they check? How frequently do they check? And can you back it up with the documentation? Next slide, please. These are a few case examples. In the interest of everyone's time, I'm not going to read them verbatim. You will be given a copy of these slides if you'd like to review them yourself, but in the interest of everyone's time, I'm going to go to the next slide. These are just some case examples of what we just went over. And now this is where I cut my teeth with the feds, stark and anti-kickback statutes. These are the not fun alphabet soup that comes in the door. If we as lawyers see this, everybody brace. The most common is billing for services not provided. ABIX, Oak Park, Michigan, in November of 2017 created an entirely sham medical practice in order to submit claims for nerve block injections that were never provided to avoid the prepayment review of his original practice. Family members and employees owned the fake practices and took 6% of all fraudulent claims off the top. The owner was sentenced to 10 years in prison and $3.2 million in restitution. Stark and AKS can apply and do apply to the billing services as well. Any request for any kind of kickback, referral fee, fee splitting, etc. should be refused. The easiest test you can run on any kind of request in this manner is to check, does the number of reimbursement or the amount of money involved go up based on the amount of patients seen by this provider, the amount of referrals made? Is there a positive correlation outside of what you would normally expect? If you get 10% for 5 people, but 20% for 10 people, run immediately. That is a kickback and it will get ugly. Valid business arrangements should be documented. You should involve healthcare attorneys specifically to develop, document, and implement any of these business arrangements, including healthcare providers. No disrespect to other members of our field, but criminal attorneys are only looking at criminal charges. Healthcare attorneys can tell you if there's a start or kickback concern from the word go. Again, case examples, I'm going to skip them just in the interest of everyone's time. Next slide, please. Self-disclosure protocols. Going back to the bullet point that I brought up earlier, it's a remedy available to both providers and billers in situations where various reporting issues would subject the provider or biller to possible CMP penalties, such as use of an excluded person, kickbacks, or self-referrals. Self-disclosure is not available for reporting straightforward overpayments or errors. You must report these yourself within 6 months of their discovery under the False Claims Act. And remember that there are usually state corollaries. These are the federal provisions. These are the overarching coast to coast, the United States says, but the state of Texas might have a similar corollary, or the state of Louisiana or Alabama, or any state that you or your business partners do business in is probably going to have some mirror statute relating to these. However, and this is why self-disclosure gets a bad rap, there are plenty of potholes. You should work very closely with a healthcare attorney to help you evaluate, analyze, and resolve your specific situation on a case-by-case basis. If your attorney is successful, you will likely have to sign a corporate integrity agreement and be subject to certain audits and performance measures akin to probation before your status is clear. I actually worked on a couple of these while I was within OSIG. They can get strenuous, but it's better than jail time. And that's a judgment call you have to make while working with your attorney. Next slide, please. HIPAA and the Business Association Agreement. The HIPAA privacy rule requires all covered entities to have a signed BAA with any business associate they hire that comes into contact with any PHI or electronic PHI. Make sure your BAA includes the updated high-tech language. Be aware of state law requirements and the fact that Texas defines a covered entity much more broadly than some of their other states, specifically to protect patient financial information. If you're doing business with someone and they're in a state that you don't know, check the local rules before you draw up a BAA or consult an attorney to have them draw up one for you. A billing company is a business associate, so be sure to have your BAA for that billing company. You should not, I repeat, should not rely on the other party's BAA to protect you from the breach. We all like to assume the best of our fellow business partners, but you can get burned. Do your own due diligence, have your own BAA, let the lawyers fight it out in the contracts of who they want to do it with. The BAA is made to protect them, not you. Have your own. Providers, make sure you can fulfill your responsibilities under the associate agreement, as you have similar responsibilities as a covered entity. You need to make sure you understand what you're signing to, because it will be brought up against you. So make sure you know what's in that BAA. and who's responsible for what. One for you and one for me. Each party is entitled to have their own BAA, so signing and exchanging BAAs is not unusual. The provisions and duties will differ, so read what you're agreeing to, and if you don't understand, ask. Most requests are reasonable and essentially require the associates to follow the law, but watch out for unreasonable or impossible requests. There is a case example with Blackhawk. Again, time, we're just going to skip over it. Next slide, please. There was a major December 2022 update to HIPAA. There is a privacy rule, patient right to access their PHI. Patients are allowed to inspect their own PHI in person and take notes or photographs of that PHI. The maximum time to provide access to PHI is reduced from 30 days to 15 days. You can request or be provided a 15-day extension on that 15 to get another 30 days, but the patient is allowed by law to see their own information. Requests by individuals to transfer electronic PHI to a third party will be limited to that electronic PHI maintained in an electronic health record. Individuals can request their private health information be transferred to a personal health application. It states the circumstances in which individuals should be provided with PHI at no costs. Covered entities will be required to inform individuals that they have the right to obtain or direct copies of their PHI to a third party when a summary of PHI is offered instead of a copy. HIPAA covered entities will be required to post estimated fee schedules on their websites for PHI access and disclosure. If you are allowed to do a fee schedule for accessing PHI, it needs to be public. You, patient, will pay X amount if we are required to pull your PHI for any reason that's not normal business purposes. HIPAA covered entities will be required to provide individualized estimates of the fees for providing an individual with a copy of their own PHI. There will be a pathway for individuals to direct the sharing of that PHI maintained an electronic health record among covered entities. Healthcare providers and health plans will be required to respond to certain records requests from other healthcare providers and health plans in cases when an individual directs them to do so under the HIPAA right of access. This is just a HIPAA request from another HIPAA covered entity saying, hey, your patient showed up here. We need their records to do our due diligence. Check the paperwork and make sure you're up to date, and then you're usually okay. But check the paperwork. Always, always, always check the paperwork. Next slide, please. Healthcare operations for HIPAA. Covered entities must obtain written confirmation that notices of privacy practices were provided. Covered entities will be allowed to disclose PHI to avert a threat to health or safety when harm is seriously and reasonably foreseeable. The current definition of when harm is serious and imminent. This means about to happen. This is not a suspicion. This is not a I have a gut feeling. This is I have reason to believe based on some evidence that if I don't get this PHI right now, there will be harm or safety to someone, the patient, someone in the direct communication of the patient, but you do need to double check all of this. Covered entities will be permitted to make certain uses and disclosures of PHI based on their good faith belief that it is in the best interest of the individual. I would like to go on record saying if you ever make a disclosure on good faith belief, document it, write it down, say why you made the disclosure, under what circumstances, to who, and what evidence did they give you, and put it in writing and put it in a log somewhere so you can lay hands on it if and when you have to. A minimum necessary standard exception will be added for individual level care, coordination, and case management uses and disclosures, regardless of whether those activities constitute treatment or healthcare operations. The definition of healthcare operations has been broadened to cover both care coordination and case management. Permission has been expanded for the U.S. military to use or disclose PHI to all uniformed services, including all branches of the military and their subsidiaries, and a definition will be added for EHR. Cybersecurity and high-tech best practices, this is where it gets really nitty-gritty. A cybersecurity safe harbor was added to the HITECH Act on January 5th, 2021. Under this law, the Health and Human Services Department must now consider the security rule best practices that have been in place for the 12 months immediately prior to the financial data breach when deciding on financial penalties and sanctions. This is when an unauthorized third party gains access to your EHR and starts pulling patient data to sell on the dark web. This is saying that the HHS, when they show up, and they will, they have to look at the past 12 months of best practices prior to the date of the occurrence. Next slide, please. If there is a breach in HIPAA, you need to investigate, analyze, and document. You need to figure out what is going on and document your analysis using the below 4-factor risk assessment. The nature and the extent of the PHI involved. What, if anything, did they get, and how much of it did they get? Second, the unauthorized person to whom the disclosure was made or who used the PHI. If you can point your finger to a specific account that may be breached, a specific series of username or passwords, or a specific IP address, if your IT team is that good, do so, but don't interact further, and we'll get to why. Whether the PHI was actually used or acquired, this is a process known as exfiltration. Just because a threat actor touched the PHI does not mean they managed to get it out of the system into some external third-party computer somewhere in the world. If you are able to tell whether exfiltration occurred, you need to know that from the word go. And if you have taken any mitigating measures, such as, I don't know, a particularly savvy IT member saw the breach occurring and cut the server, note that. Put it in writing so that the attorneys, when the feds show up, can say, no, we saw it and we cut them off as best we could from the source. There are notices that must go out if the HIPAA breach is wide enough. Business associate must notify the covered entity of a breach without unreasonable delay and at the latest within 60 days of the discovery. If there are more than 500 patients affected, the covered entity must, again, must report the breach to the Office of Civil Rights, also known as OCR, without unreasonable delay, and again, no later than 60 days from the date of the breach. They must notify local media within 60 days if more than 500 patients are involved, and they must notify all affected individuals within 60 days. The burden of proof for all of these actions is on the covered entity and the business associate to demonstrate that all HIPAA HITECH requirements were met and that the disclosure was not a breach. Remember that these HIPAA task force teams are in the field and can use the civil monetary penalty law. The short version for all of this is keep a well-designated cyber team together. If you are breached, shut it off quickly and do a damage count of how bad is it as soon as possible, because it's going to get ugly. There is a case example. We're going to skip it for time. Next slide, please. CMPs on or after February 12th of 2024, there are tiers to how bad these penalties can get. The first is the lack of knowledge. My actions did constitute a breach of HIPAA, but I didn't know it, and I wasn't trying to breach HIPAA. The minimum of $137 to a maximum of $68,000 with an annual cap of $2 million, give or take some change. So just because you didn't know doesn't mean it wasn't a breach, and it can get expensive. Reasonable cause without willful neglect. I did it, but I didn't mean to. It was an accident. I'm sorry. Minimum of $1,379 fine up to a maximum of $68,928, again with the annual cap in the $2 million range. Willful neglect, corrected within 30 days. I breached HIPAA. I meant to breach HIPAA, but I fixed my breach. I did some kind of action on the back end. Congratulations. This is where the money starts coming out of your pocket. There's a minimum of $13,000 fines up to a $68,000 fine with an annual cap of $2 million for singular entities. And tier 4, willful neglect, as in I did it, I meant it, and I'll do it again because I didn't fix it. Minimum of the previous cap. Again, the minimum that they can hit you with at tier 4 is the maximum cap of all three other tiers. And it can go up to the annual cap in a singular interaction. It can be one and done, you're paying $2 million. The minimum fine for intentional and uncorrected release of PHI is currently $68,928 if the offender is a covered entity or business associate. If the offender is a member of a CE or BA's workforce, i.e. an employee, and they violate HIPAA intentionally with criminal intent, there is no set minimum, and the courts can assess a fine of up to $250,000. Next slide, please. Patient abuse or neglect. So this is where hospice really starts taking notice. Discovery of patient abuse or neglect. Most states have mandatory reporting laws that make reporting an affirmative duty. In Texas, that law says anyone with knowledge of suspected patient abuse or neglect of a child, adult with disabilities, or adult over 65 must report it to the Department of Family and Protective Services. This applies to every individual and is not limited to healthcare professionals. Remember, HIPAA is not an impediment to reporting abuse or neglect. It takes precedence over privacy limits. It is one of the few exceptions, but it is an exception. If patient abuse or neglect is suspected, you must report. Individuals who make reports in good faith are generally immune from civil or criminal liability for such reports. Next slide, please. To get a favorable solution, again, hire legal counsel, determining what the potential problem is and whether it appears to be a simple overpayment that can be addressed through the returns of funds for a particular service, or whether it's a more widespread interference or it's a result of fraud. If it looks to be anything more than a simple overpayment for a service and you don't know, ask your attorney. Contact a lawyer immediately. Get legal counsel. First of all, we offer provider attorney-client privilege. For an internal investigation, outside legal counsel can generally privilege any communications during the investigation, whereas communications made between employees and officers are unlikely to be privileged, especially if not done at the direction of counsel. This is the magic. You don't get to ask what I said to my lawyer card. Use it. Hire a lawyer. Counsel can also assist in determining a strategy for proceeding, including the preservation of documents and email, employee interviews, and in the event of an overpayment, advising on the scope of any further inquiry past the initial service discovered, including whether a stat analysis is required to quantify the problem and where an overpayment may need to be refunded. If there is fraud, legal counsel can assist in determining whether, when, and how to approach the government. I promise you, you want a lawyer who is trained in healthcare matters to make that judgment call over any officer of the organization, no matter how much you think you don't. If there's fraud in the room, you want a lawyer. I promise you, you do. Extended privilege. Legal counsel can also assist you with issues that may have been created by your billing department or third-party contractors, including the billers themselves. Most importantly, contact legal counsel early on and get contractors, consultants, or other experts included under the attorney-client privilege. It just is the best way to do it. Trust us. Next slide, please. And this is the last one. To reiterate, this outline is provided as general information. It is not direct legal advice. You should hire a lawyer for your own case if and when a case arises. And we are Richard and Matt with Lyles Parker. Richard, you got anything to add?
No, I apologize that we ran a little long, but I wanted to check with Jill and see if we have any questions.
No, unfortunately, we do not have any more questions. I think you guys went through it, most of them. So I'm going to just close out. So that concludes today's webinar. Thank you for joining us, and thank you to our speakers, Richard and Matt. Everyone from today's webinar will receive copies of the presentation tomorrow via email. If you have any further questions about today's discussion or another healthcare law issue, please feel free to reach out to the speakers or directly to Lyles Parker. Have a good Wednesday and take care. Thank you, guys.